to say this and this alone, that our Article 32 rights are violated.
I don't think we can take it that far to say that, as you have said in your first point, that to say that this is a matter for Parliament seeks to impose a British parliamentary form. That may be a very, it may not be really a very correct way of stating it.
My Lords, my 5 distinct points are one, this. Contrary to what the Union has advanced in its counter and in its opposition in court, India's parliament, in India, the parliamentary form of government that we adopted as we the people when the Constitution was adopted, unlike England, is a constrained parliamentary form. In England, parliament is sovereign. In India, simply put, parliament is constrained. Constrained by what? Constrained by the Constitution as interpreted by whom? My lords. That is the separation of powers formula that we the people gave ourselves. So to say that this is a matter for Parliament is not just unknown to the Indian parliamentary form, which is constrained by the Constitution, but in fact seeks to impose a British parliamentary model, which has no place in this jurisdiction.
Constitution, yes.
Judicial review is part of basic structure. Of course, my lords, it's well established. Kesavananda, Minerva Mills, so on and so forth. Dr. Ambedkar in the Constituent Assembly debate says Article 32 is the soul of India's constitution. Why is this important? Because these petitioners in 19 petitions, speaking for, if arguably 5 to 7% of any country's population identifies as LGBTQ, then speaking on behalf of millions of Indians, come to my lords to say this and this alone, that our Article 32 rights are violated. And as my Lord the Chief Justice said, most importantly in this preamble, that we the people gave ourselves, the people of India having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens. That's 32. So the government of India cannot come to court and say that we the people, and we may be a minority or a substantial part of this population, cannot come to court and say that this is a matter of Parliament, because our Article 32 rights, the right of judicial review, is part of the basic structure of this Constitution, of which this basic structure doctrine we have now celebrated 5 decades. Those 5 decades belong to LGBTQ people also. My lords, point 3. And again, I will only take my lord to the specific paragraphs.
What is the point 2?
My lords, point 2 is Article 32.
All right, that's all.
Yes, my lords. Is point 2, and I'll take my lords. That's also the second point of the written submissions, my lords. My lords have the index, so I won't trouble my lords with repeating any points that have been dealt with. My Lady Justice Kohli has the index also, my lady.
Yeah.
I'm grateful. Point 3, my lords. The Union in its counter has said to us that they have a legitimate state interest in proscribing this nature of marriage. My lords, the Chief Justice, 9 judges in Puttaswamy, have interpreted legitimate state interest as specifically pertaining to national security, crime, innovation, and dissipation, prohibiting dissipation of social welfare benefits. That is the understanding of when can the state ascribe and highlight such legitimate state interest. This is point 3. Nowhere in these cases, in these petitions, does the state meet that heightened requirement. I'll take my lords to the two relevant paragraphs there, which are also in my written submissions. That marriage is a matter of conscience under Article 25 of the Constitution of India. Now, my lords have heard arguments on Article 14, 15, 19, 21. They are all extracted in my submissions. I adopt my comrades at the bar who've advanced those arguments. I'm not going to repeat them. They're part of my written submissions. But marriage is also a matter of conscience under Article 25 of the Constitution. And that is my point 5. Finally, my lords, there is a workability table. I will not trouble my lords, but just to say that it is part of the submissions. But the final point I want to say, and I will come back to this also when I deal with the submissions of the statutory body, that is DCPCR, is that our Annexure 6 in my submissions is the only study that is based in India. It has 5,800 respondents, and the study speaks to, one, the journey post-Johar, how it has impacted LGBTQ people, and two, how marriage equality will impact LGBTQ people, and that is a substantial portion.
Dr. Guruswamy,
Yes, my lord.
the point really is that the fact that the canvas which is covered by these petitions also falls within the, or does fall, let me not say also, does fall within the domain of Parliament is undisputed. You cannot dispute the fact that Parliament has legislative power over the canvas which is covered by these petitions, which is entry 5 of the concurrent list.
My lord.
Because just let's see entry 5 of the concurrent list of the Constitution.
Yes, ma'am.
It specifically covers marriage and divorce, infants and minors, adoption,
Yes, ma'am.
wills, intestacy and succession, joint family and partition, all matters in respect to which parties in judicial proceedings were immediately before the commencement of the Constitution subject to their personal law.
My lord.
Right? Therefore, entry 5 also recognizes the position that all matters which prior to the Constitution were a part of the personal law fall now within the domain of Parliament under entry 5 of list 3. Therefore, there's no gainsaying the fact that Parliament does have. So, for us to say that, to accept the submission of the Union would be to transplant the British parliamentary model may not be entirely correct. You are right that the British Parliament, at least before the Human Rights Act,
Yes,
was untrammeled. It was a sovereign. It was an expression of the sovereign will
Yes,
of the people, and therefore judicial review couldn't certainly extend to striking down a law. Even today, you have the doctrine of incompatibility. But equally, that really begs the question, because our Parliament has specific jurisdiction in legislative terms by virtue of Article 246, read with entry 5 of List 3,
my lord.
to legislate on this area.
My lord.
Now, the question which we really therefore have to pose is that if this is a power which is conferred specifically on the Parliament, does the court then, where does the court really exercise jurisdiction?
Very well.
Which are those interstices which are left open for the court to exercise its power? Therefore, I don't think we can take it that far to say that, as you have said in your first point, that to say that this is a matter for Parliament seeks to impose a British parliamentary form. That may be a very, it may not be really a very correct way of stating it.
My lords, may I respond with this, my lords? The argument, my lords, is simply this, that in these areas where there has been legislation, the Special Marriage Act, for instance, in these areas where there has been legislation, the Special Marriage Act, read in conjunction with well-established case law by my lords, both this nature of case, what is the function, what is the width and ambit of Parliament, along with cases like Puttaswamy and Johar, which my lords have made clear that fundamental rights cannot be trammeled. The argument is simply this, that these have to be read conjointly, that we cannot have a situation where the state, when it is remiss, either in discussing something, in creating that positive obligation that my lords have spoken about, both in Puttaswamy and in Johar.
Dr.
That my
Guruswamy,
lords,
just